Hello and welcome. My name is Malcolm Neekirk. Today's coffee break briefing is on the subject of converting members' voluntary liquidations to creditors' voluntary liquidations. It's a follow-on from last month's espresso coffee break briefing when I looked at the Novalpina decision, which has thrown this into new emphasis. I've got quite a lot of ground to cover in this presentation, so I'm going to skip the usual parish notices and just move straight on with the presentation to cover the topics that we need to look at. So today's topics, I'm going to be looking at, first of all, what it is that triggers conversion. What point is it where you need to convert an MVL into a CVL? I'm going to move on to look at the procedure of conversion and choosing the new liquidator. I'll have a quick look at how you deal with disputed claims in that situation, and I'll finish with looking at the conversion timetable and the time limits on that. And after that, I hope there may be time for any questions if you've got any. So let's start by looking at what it is that triggers conversion of an MVL into a CVL. And this is set by section 95 of the Insolvency Act. And the trigger point is reached when you think that the company is going to be unable to pay its debts in full within 12 months from the start of the MVL. Now, I talk about the period of 12 months. It's actually the period set by the director's declaration of solvency. That can be for a shorter period than 12 months, but I think it always is for the maximum 12-month period. So when I talk about 12 months in the context of this presentation as being the time in which debts have to be paid in full, I actually mean the period set by the declaration of solvency, but it's always going to be 12 months. Novalpina raised fresh insights into that, and Judge Agnello there drew an important distinction between MVLs and CVLs. She said the key is not whether the company is solvent or not. The key is whether the company has paid or will be able to pay its debts within 12 months from the start of the liquidation. And I think that means that we now have to think about voluntary liquidations as falling into not two categories, but three categories. Previously, we always considered voluntary liquidations to be either solvent, in which case they would be an MVL, or insolvent, in which case they would be a CVL. Now we have to think about MVLs. We have to think about the vast majority of CVLs which are insolvent CVLs, and we also have to think about a small number of solvent CVLs, ones where the creditors will not be paid within 12 months, but where there is every expectation that they will be paid in full at some point during the course of the liquidation. And there can be some difficult cases that I've certainly seen in the last few weeks about when you have got claims that may not be paid within 12 months. And one example can be if it's taking a long time to agree the company's position with HMRC. And what I've seen some liquidators do there is to actually overpay HMRC now. And that then converts HMRC from a creditor into a debtor, and therefore there's no question then about not being able to pay HMRC's debt within 12 months because the debt has already been paid. And when you get to the conclusion of the company's tax affairs, there will actually be some money coming back. Now, this might mean that the MVL runs on for longer than would otherwise be the case because you're going to have to wait to reclaim the money from HMRC and to get it back. And that might take longer than simply paying a debt to them. But that's perhaps a sensible approach. Other cases I have been looking at have been ones where there's been a third party has actually shouldered the responsibility for paying the particular liability. And examples of this can be either if it's an insurance company that's going to be picking up the tab for the claim, or if there is some third party that has given an indemnity for commercial reasons for it. Now, the normal legal position is you can't assign a liability. And normally, if you wanted to take a claim out of the scope of the liquidating company, you would need to novate it or use some other procedure that actually involves the creditor releasing the liquidating company. But these have been cases where there is no release, no legal release of the liquidating company's liability. And in some of these, we've been considering that, for example, it looks as if it's going to be a claim that the insurance company is definitely going to pick up and will definitely cover all of it, but from the excess. And so we've had liquidators there who've been thinking about, well, if we were to pay the excess now to the insurance company, does that sufficiently get the claim off the company's books that we can treat it as a claim that is not going to be unpaid within 12 months, because it's just a claim that the company itself is never going to have to pay because the insurance company is going to pay it. And similarly, you might be able to treat the claim that's being indemnified in much the same way and say, well, the company is never actually going to have to pay this liability. It will be a third party that is definitely going to pick up full responsibility for it. So that brings us back to this question of when is the obligation to convert triggered, and it is at the point when you think that the company is going to be unable to pay all of its debts in full within 12 months of the start of the liquidation. And there are statutory obligations on a liquidator when that happens. You have to draw up a statement of affairs. You have to ask the creditors who they wish to have as liquidator from that point onwards. And if the creditors choose somebody else to be the liquidator, it is normally the creditor's choice of liquidator who will prevail. If the creditors don't replace you, they don't appoint another liquidator, then you will continue in office as a liquidator. And the point at which the MVL becomes a CVL is the point at which either the creditors have appointed a new liquidator or that procedure for appointing a liquidator has run its course without a new liquidator being appointed. So let's start by looking at the Insolvency Code of Ethics. And as you know, this is there's a new code coming into force, I think, next month, in October. And this is the text, taken from the text of the new code. The essence of it is that if you are a liquidator in an MVL and it's converting to a CVL, you should vacate office, you should stand down as liquidator, unless it is going to be a solvent CVL, one in which all of the creditors will be paid in full, albeit after more than 12 months from the start of the liquidation. But even then, you may not be able to continue in office. Let's look at the rules themselves and what they say. You'll be familiar with rules 614 to 617, which are the rules that apply for the appointment process in most ordinary CVLs. Those don't apply to an MVL that's converting to a CVL. Instead, you'll be looking at rules 611 and 613. The rules converge again when you start looking at rules 618 and 619, which apply to all CVLs, whether starting as CVLs or starting as MVLs. And in case you don't remember what 618 and 619 say, 618 is how you run a contested vote if there is more than one candidate standing for office as liquidator, and rule 619 is the one that says that every time you ask the creditors to vote on something, you have to invite them to form a committee. So looking at 611 through to 613 and what is different about that procedure from the one that you would normally follow when being appointed in a CVL. First thing we come in with is that you've got a wider option of procedures to follow. Under 614, you can only be appointed as liquidator through either a virtual meeting or by deemed consent. If you're converting from an MVL to a CVL, you can use other decision procedures. You can use the distance voting procedures, for example, as an alternative to a virtual meeting. Now, as it turns out, following the timetable to do that would be incredibly stressful. And for that reason, I would recommend that you don't do it. And for practical reasons, if you're looking at converting an MVL into a CVL, I think you should be choosing the procedure to follow as either a virtual meeting or deemed consent and not any other procedure. The other thing that's different is that you will need to send the creditors the statement of affairs with the first notice that you send to them. Under the normal CVL appointment procedure, creditors may receive the statement of affairs only the day before the decision procedure itself. They get much more time in this procedure. And the note at the bottom of that slide is a reminder to you that you should be asking the creditors for formal release from liability as one of the resolutions that you're asking them for if they're not going to allow you to remain in office. This slide really is just reminding you of two things. One is that the notices are actually quite different in form, and you need to make sure that you've got the right details in the 611 notice, which is going to be rather shorter than the 614 notice. And the second thing is that the timetable is a little different. You've got to give 14 days notice to creditors of the decision date, and that is longer than the normal notice that they get if it's a company going into liquidation, into CVL for the first time. The other thing that I'd like to emphasize on this particular slide is that the decision date has to be no later than 28 days after you realize that you have to convert the MVL into a CVL. Now, there's nothing in the rules about advising or consulting the members or the directors about the conversion. Now, you will, of course, do that anyway, but you've got to be very careful that you don't trigger that obligation to convert sooner than you would. Once you have decided that the company is going to be unable to pay its debts in full within 12 months, that's what I'm calling later in this presentation the expletive date, and you have to set the decision date no later than 28 days after the expletive date. So if you start sounding out the directors and the creditors at that point, and it looks as if you've already realized that the company is going to have to convert into a CVL, you might find that you are in default under your obligation to set the decision date within 28 days after the decision, after the expletive date. So you do need to be very careful about what you say to directors and shareholders once it becomes apparent there's a real risk that you might have to convert into a CVL. You don't want to find that you've triggered the decision date and then missed it. Once you sent the notices to creditors, there are, they can go along with your proposal, of course, and you would hope that they would. If they don't, they've got a couple of options. They can either object to the liquidator that you put forward, whether that's yourself or another, either by blocking deemed consent, if that's the route that you're taking, or by voting against that appointment at the decision procedure. They've also got the option of objecting to the manner in which you are asking them to decide who the liquidator is going to be, whether that's a decision procedure or whether it's deemed consent that you're using. And if you're using deemed consent, then it will take 10% of creditors by value to block that deemed consent, in which case the deemed consent notice fails, and you then have to move on to try a different way of appointing the new liquidator. The other option that creditors have got is to use the rule of 10 to demand a physical meeting of creditors, and that will then put a stop to the deemed consent or the decision procedure that you have started, and you then have to change course and set up a physical meeting for the decision to be made. And the rule of 10, it means that the block can be triggered by either 10% of creditors by value, or 10% by number, or by at least 10 creditors in number. Now, what happens if the appointment is being run by deemed consent and 10% of creditors object to it? You then have to set up a vote by a qualifying decision procedure, and you have to give at least 7 days notice of that vote, and the decision has to be no more than 28 days after the date on which the objections amounted to 10% of creditors. Now, the qualifying decision procedure does not have to be at a meeting. Any qualifying decision procedure will do, including a distance voting procedure. And this is one situation where actually the timetable for distance voting might work and is perhaps not going to be too stressful. I'll talk about that a bit later on. What happens if creditors call for a physical meeting? In that case, you have to set up a physical meeting. You have to give at least 14 days notice of the date of the physical meeting, and it has to be held not more than 28 days after the date on which the rule of 10 was triggered. And Rule 612 sets out how you have to run a vote to appoint a liquidator if it's being done by distance voting rather than at a virtual meeting or a physical meeting. And that requires a two-stage process to do that. First part of the process is essentially canvassing views of the creditors. You ask them to put candidates forward. The candidates, of course, have to be qualified insolvency practitioners, and they have to let you have a consent to act. But essentially, there are 5 business days that you allow the creditors to put forward the candidates who they wish to have on the voting slip. Once that canvassing period has finished and you've got the names of candidates for the voting slip, that's when you can then run the decision procedure. You have to do that within 2 business days after the canvassing period has run, but you then send out further notices, which will be the normal voting by a decision, voting by a remote vote procedure sort of notice that you use in that situation. So it's a 2-stage process. Firstly, the canvassing to get the list of candidates for the voting papers, and then secondly, the election itself, which will be done by some distance voting procedure. We now move on to look at what you have to do once the MVL has converted to a CVL, what the immediate obligations are following the conversion. And these will be obligations for the new liquidator, assuming that somebody else has now taken over the job from you. They will have to report the conversion to creditors within 28 days. There is also filing at Companies House. The statement of affairs has to be filed within 5 business days, notice of appointment of the new liquidators within 14 days, and similarly the new liquidators have to be gazetted within 14 days. And other consequences of the conversion, as I said in an earlier slide, the date of conversion is the date on which either the creditors appoint the new liquidator or the appointment procedure ends with you remaining still in office on that at the end of that procedure. Second consequence is that the declaration of solvency that the directors originally swore becomes irrelevant, and it's treated as if they had never sworn that declaration of solvency. And the liquidator will normally be whoever the creditors have chosen. If the creditors have not chosen anybody, you will continue in office as liquidator. And the court has always got the option of stepping in and appointing somebody else despite the choice of the creditors. The normal rules about release apply if you're being removed. I won't say any more about that. And there is always the possibility that even though you should not continue in office, or you don't want to continue in office, you might find that, for example, the creditors block the deemed consent of the liquidator that you proposed as an alternative. And then when you tried again at a virtual meeting, nobody turns up to the virtual meeting, so nobody votes for a replacement liquidator, in which case you will continue in office as liquidator. And it might be that you can't continue in office for ethical reasons, or you don't want to. And if you remember, those ethical reasons are that if it's not going to be a solvent CVL, you can't stay in office. And if there are unacceptable threats to compliance with fundamental principles, you can't stay in office. So you might find that you are conflicted from staying in office, but you are still the liquidator despite that. I've identified these three options. There may be others. You could resign, and one of the circumstances in which you are allowed to resign as a liquidator is if there is a conflict of interest that prevents you from continuing in office. And I think you would be entitled to say that there is a conflict of interest if ethically you should not be staying in office. I think that would be fair enough. And when you resign in those circumstances, you then run a further decision procedure or deemed consent for creditors to appoint a new liquidator in your place. And you'd have to hope that that is going to work on that occasion. You could ask the court to appoint a new liquidator in your place and to remove you. This would be like a block transfer order, but with just one appointment rather than lots of appointments. And I think the courts would normally be quite sympathetic to that situation. You will, of course, need a new liquidator who is able to act and is consenting to act to be appointed by court order in that situation. Or you could apply for directions, and I suppose it is theoretically possible that you could ask the court to allow you to remain as liquidator despite the ethical complications if no other liquidator can be appointed for whatever reason. I think the court would be very unhappy about being asked to do that and be very reluctant to do so, but as a last resort, that might be something to consider. So that's my quick summary of the procedure to follow to convert an MVL into a CVL, and the options that you give to the creditors, how you give it to them to appoint a replacement liquidator or to reappoint you as liquidator as may be appropriate. Now, you're often going to find that you're having to deal with disputed claims in an MVL that's converting into a CVL. If the claims were straightforward and undisputed, you would simply pay them, and that would prevent the need to convert to a CVL. So it's quite likely that in a case where you're having to convert to a CVL, the claims of creditors are going to be complicated, disputed, difficult. And you're going to need to look at the way to assess creditors' voting rights in rules 1528 to 1535. And you'll have to remember as well that unlike most CVLs, where the director is technically chairing the meeting of creditors or the convener of the decision procedure, in a conversion from an MVL to a CVL, you as liquidator are chairing the meeting or are the convening of the decision procedure. So that makes things a little bit different. The general rule is that it will be your job to decide whether to admit or reject claims and whether to admit or reject in whole or part. And you'll have to remember that what Rule 1533 says is that if you are in any doubt, you shouldn't reject the claim. You should mark it as objected to and allow the creditor to vote. So effectively, you're giving the benefit of the doubt to the creditor for voting purposes in a situation like this, and it would then be for the court to decide whether that creditor's vote should be admitted for the full amount or whether the result should be overturned if it's a material change. Now, in many cases, you will have accepted that you're going to be removed as liquidator anyway, that there will be a new liquidator in the CVL. So you may not have any particular interest in who should be the new liquidator and which way this particular vote goes. If you have got a particular interest, and it's about whether you stay in office or not, then I think that might be a case of looking on ethical grounds whether you should be continuing in office anyway if you feel you've got that much of an interest in the state. You've always got the option of putting an estimated minimum value on the claim for the purposes of entitlement to vote and then admitting the claim for that purpose. So you don't have to accept at face value whatever figure the creditor is giving. You can investigate and assess and put an estimated minimum value on it. And I think that when looking at the estimated minimum value, you need to look at both the quantum of the claim, how much is the creditor claiming, and also what their prospects of success are with the claim, what the potential liability is, whether this is a claim that you would expect the company to have to pay, or whether it looks like it's a very, very doubtful claim. Most, of course, will be somewhere in the middle. So that's a quick look at disputed claims. I now want to finish by looking at the conversion timetable itself. And just with this reminder that it is very, very tight, that once you have decided that the company is going to be unable to pay its debts in full within the first 12 months of the MVL, you then have a legal duty to convert it into a CVL, and the decision date for that conversion has to be no more than 28 days from the date on which you made that decision. So you do need to be very careful if you're sounding out shareholders and directors at the time when you're thinking you might have to convert. So this is just a diagram to show you've got the expletive date on the left-hand side when you realise that Section 95 is triggered. You've got the conversion date on the right-hand side, which has to be no more than 28 days from the expletive date. And you have to give at least 14 days notice of the decision date to creditors. And that has to be 14 days after you have delivered the notices to them and the statement of affairs. So you need to allow whatever time it's going to take for delivery of those as well. So in actual fact, you've probably got only about a week from the day that you realise that it's going to have to convert to a CVL until you have to prepare the notices and send them out and have a decision date set. You really don't have a great deal of time at all. And if you're using another decision procedure, distance voting, for example, it's even tighter, because if this is the first procedure that you're using, if you're going straight from expletive date to a decision by distance voting, remember you've got to have this two-stage process where you start by canvassing for candidates for the ballot paper, and then once that first stage is finished, you then conduct the ballot itself. And the ballot has to be on at least 14 days notice, and you have to allow time for delivery of the ballot papers within that. And it's going to take over a week for you to run that first canvassing part of the process. So when you've only got 28 days and you've got one party is going to take more than 2 weeks and the other party is going to take over a week, you really don't have very much time at all, which is why I don't recommend using distance voting as the first procedure to appoint a new liquidator in a case like this. The timetable becomes much easier if you've started by using deemed consent and the creditors have blocked deemed consent. In that case, if you then move from deemed consent to remote voting, you only have to give 7 days notice pardon me, of the ballot paper, and that makes the whole timetable quite a lot more relaxed and makes it feasible. So I think that's the situation in which you might be able to use that procedure. So that then brings me to the slide that says any questions. I see there are a couple of questions that have come in already, so I will have a look at those now and see what we've got. First one is, what happens to statutory interest on conversion? Well, statutory interest continues to run, and creditors are entitled to be paid in full, including statutory interest. So if you can't pay statutory interest in full, it could be an insolvent CVL. Second question is, are there any restrictions on the MVL liquidator once the Section 95 procedure is triggered, i.e. realizations of assets and so on? So that's a really interesting question, and the answer is no, there aren't any statutory restrictions on what you can do. I think you would have to be guided by common sense in a case like that. If you had already been dealing with a sale transaction and it gets to the point where you are now able to exchange contracts and it's a sale which is entirely justified, then by all means go ahead and exchange contracts and conclude it. But if there's anything contentious, you might simply be making life unnecessarily complicated for yourself if you go ahead and realize assets in the dying days of an MVL where you're about to hand over to a CVL and there's going to be a new liquidator and possibly a hostile creditor leading on that liquidator. It may be a bit tactless in a situation like that to sell something. Another question, does the appointment of new liquidators on conversion reset the reporting timeline, or does the timeline for the MVL continue? I'm afraid I don't know the answer to that. I didn't check that before I prepared these notes. I will have a look and see if I can find the answer to that, but I'm sorry, I don't know the answer to that. And yes, there's a comment which is that I hadn't seen this, is that we've now got guidance from ICAEW on the Novalpina decision, and I haven't commented on that. I haven't reviewed that yet, but I will have a look at that and see whether there's anything on that that is going to make me change anything I've already said about these. Now, yeah, I've lost the dashboard I was looking for. That's got it back now. So I think that's all the questions I've got. As always, please do feel free to drop me a line or give me a call if there are any other questions you'd like to ask about this. Thank you all very much for watching this. Few dates for your diary coming up. Thursday and Friday this week is, of course, the SESCA Insolvency Conference in Reading. If you are planning to go to that and you have not yet booked, suggest you book immediately. I assume there are still tickets available, but I can't guarantee that. There's the SESCA Denbiz seminar coming up on, I think it is the 2nd of October. That's usually a very good event, so please do book yourself on that if you have not already done so. My next coffee break briefing will be the Monday after that, which I think is the 6th of October. I'm presently thinking that I'm going to revert to form and talk about a very old case that everybody has forgotten about, and I'm thinking about doing a session on the case of Ree James, which is one that's frequently thrown at insolvency practitioners as a way of saying that we should be tempering our behaviour in various ways, usually to benefit the disgruntled solicitor's client. But I'll be having a look at that case and what it really amounts to. And then we've got the R3 SPG forum at the end of November, which I will be going to. That's at Stratford-upon-Avon, I think, this year. And there's also the R3 Personal Insolvency Forum early in December. That's in London. I went to the Manchester Personal Insolvency Forum earlier this year, and I thought it was a really good event. So I can recommend the R3 Personal Insolvency Forum if that's what you do. And I've got a comment here where I said I didn't know what the issue was with reporting, and thank you to Sarah Mercer about this, who says the commencement of voluntary liquidation remains the same, whether it is MVL or CVL. That's certainly true, yes, and saying therefore the reporting period does not change and is still annual from the date of passing the winding up resolution. So the former liquidator will complete their part until the date of the removal or release, and the new liquidator will then file on the anniversary with the usual 2 months to do that. So thank you very much. Very helpful comment there. I'm very grateful to you for that. And with that, I think that's everything. So thank you all very much. I'll say goodbye, and I will see you next month for the next coffee break briefing, unless we bump into each other at a conference before then or at some other event. Thank you very much. Goodbye.